Hello there, and welcome to this Law Society webinar on the future of UK-EU data flows post-2020, being recorded on the 30th of September 2020. This is a webinar that is being streamed live on YouTube, and I am pleased to welcome you to this event. My name is Peter Wright, and I am the chair of the Law Society's Policy and Regulatory Affairs Committee, chair of the Law Society's GDPR Working Group, and also author of a manual on GDPR. So I've been doing a lot of work with regards to data protection and international data transfers for a number of years. I'm also managing director of a law firm, Digital Law, where I do a lot of advice for clients all around the world on international data transfers. In preparation for our panel discussion today, I thought, well, why don't I look at other examples of cutting edge debate around the world? So I watched a debate last night that was being streamed on a lot of different channels. And I looked at the people who were taking part, and I looked at the job that Chris Wallace, the host of that, had. And I decided to turn away from that in terms of insight, and after about 15 minutes thinking this isn't how I want our discussion today to go. So that was my preparation for today. I'm pleased to say that we have over 430 people who've registered with us for our discussion this afternoon. Thank you all very much indeed for joining us. I think we have people registered from across the UK, from across Europe and around the world. So thank you for joining us for our discussion. You will be able to ask questions. If you log into the live stream on YouTube, you'll be able to put your questions in on the chat facility, which you can, if you click below the bar on the video where you're watching us, you'll be able to see the chat there. You can then put your comments and questions in there, and we'll be able to see them where we are, and then we can select different questions during our discussion. We're scheduled to run for an hour and a half today, but in the event there are any questions that we are not able to answer during the course of our discussion, then we'll also hit any other questions in a Q&A at the end of our panel. The aim of our event today is to flag up and clarify key issues of concern with regards to data protection and cross-border data transfers between the EU and the UK after the transition period ends on the 31st of December 2020. Therefore, we are looking to advise members, to advise lawyers, practitioners out there on what steps they need to take to prepare for the end of this transitional period that we are currently in. Bearing in mind that as we speak now, there are just 3 months left until that transitional period expires. So to discuss these issues today, I'm pleased to say I'm joined by an expert panel of specialists. And we're just going to sort of go around our virtual table so that they can all introduce themselves in their own words to you. First of all, I'm going to go over to Anna at the Law Society's Brussels office. Anna, hello.
Hi, hello everyone. Thank you very much again for joining, and thank you very much for having me on the panel and for such a great company. I'm looking forward to the discussions. My name is Anna Drost and I work for the Law Society's Brussels office, and I'm one of the persons who's responsible for data protection technology, but also several other dossiers in the office. Thank you.
Thank you, Anna. And Charlie.
Hi, I'm Charlie Smoothie. I am a civil servant in DCMS, which is the Department for Digital Culture, Media and Sport. I'm a senior policy advisor in data protection and international data transfers, specialising in international and security related departments. Thank you all for being here.
Brilliant, thank you, Charlie. And Anna from EDPS.
Yes, hello everyone. Thank you, Peter. I'm the other Polish Anna on this panel. My name is Anna Buchta. I'm the head of Policy and Consultation Unit at the European Data Protection Supervisor's Office. So we are the EU regulator for data protection, the counterpart of the ICO in the UK. We are also a member of the European Data Protection Board. And in this capacity, we are recently working with our national colleagues on the fallout from the Schrems II judgment and on guidance on supplementary measures. I'm very happy to be here with you.
Thank you very much, Anna. And finally, Rhys.
Thanks, Peter. Hi, everybody. My name is Rhys. I'm also a civil servant. I work in the Legal Services Trade Division in the Ministry of Justice. So for this, I work on international market access for UK lawyers, for firms, and some of the barriers that they encounter overseas. Alongside this, I also work on the sector's interests in government digital trade policy and also international data transfers. And it's also a pleasure to be here virtually with all of you today.
Thank you very much indeed. So that's our expert panel. Now I want to dive in really with our discussion, and that's to first of all ask our panel generally. What do we think the impact of the UK's withdrawal from the EU and the impending end of the transition period? What's the impact of that going to be on organisations that process personal data from the European Economic Area? I suppose I should just clarify there, European Economic Area, of course, is we're talking about the 27 EU member states plus Norway, Iceland and Liechtenstein. So what do we think is going to be the impact of that withdrawal on organisations that process personal data from the EEA? Who would like to come in on that one first? Anna B?
Yes. So maybe, Peter, I don't know whether that's okay with everybody, but I can maybe speak a little bit about the institutional setup and where we are at in these discussions, because as a regulator, this is what I'm more familiar with than let's say, impact on the ground in terms of actual data flows. So maybe as a scene setter, and just to make sure that everybody is on the same page, I would propose to start from that, if that's okay.
Please do.
So, as you know, Britain has unfortunately left the EU at the end of January of this year. And so from the point of view of European law, including the rules on data protection, has become a third country. Thankfully, there is the withdrawal agreement, which for the time being provides for the possibility to transfers of personal data to continue both ways on the basis of previous rules, of existing rules. So currently, personal data can still be transmitted from the EU or from the EEA to the UK without any restrictions. And by the way, the withdrawal agreement also contains provisions according to which this data will have to continue to be processed according to current rules also in the future. So after the end of the transition period. The things will unfortunately look slightly more complicated, or may look slightly more complicated after the end of the transition period. So after the 31st of December this year, as I say, this is where the normal GDPR rules or law enforcement directive rules for transfers of personal data to third countries will kick in. And there we will have a number of possibilities, the first of which is the adoption by the European Commission of a so-called adequacy decision. And this is at the moment the intention, in line again with the European Union commitment to negotiate the future partnership with the EU. This also is linked to two possible adequacy decisions, one governing, let's say, commercial data under the GDPR, and the other for law enforcement context and authorities under the law enforcement directive. This is one possibility. The GDPR obviously also offers other tools, such as standard contractual clauses, in short SCCs, binding corporate rules, as well as a number of derogations for specific cases. Nevertheless, obviously, the adequacy decision is possibly the best outcome that we can all hope for. And there is a certain level, I believe, of commitment still on the EU side to deliver those adequacy decisions. I would like to stress, however, that this is a separate process. So these discussions about possible adequacy are a separate track and not part of the overall negotiations that are still taking place, as you know, about the future relationship between the EU and the UK. So maybe I would leave it at that for the time being, and then we can dive into some of the details and questions. And I'm sure my co-panelists will have a lot to complement this. Thank you.
Brilliant. Thank you very much for that, Anna, which covered a lot of sort of introductory points there and opened up a lot of the issues that we'll be talking about over the next hour and a half. I suppose I just wanted to, as well, we just covered it there. You mentioned a couple of quite important areas and quite important mechanisms, one of which is SCCs, those standard contractual clauses. I suppose we should make clear that those aren't just, for example, a couple of paragraphs that need to be cut and pasted into contracts. We're talking about quite large, detailed annexes that would need to be present in any contracts in order for them to clearly contain those SCCs. And then there's also binding corporate rules, which would allow organisations to say, yes, we're moving data around our global organisation across through offices, for example, in the EU and UK, according to those binding corporate rules. But they're quite, it's quite an exercise to get those incorporated and then signed off. Anna, at the Law Society, I'm just going to briefly come to you because I know you've been working on some guidance that's going to be going up on the Law Society website on this, just with regards to those mechanisms and how they should operate. So I just wanted to sort of bring you into the discussion at this point, just with regards to the impact of those and the fact that it's going to be something that, in the absence of an adequacy decision, that's something that our members will clearly have to have at the forefront of their minds.
Yeah, thank you, Peter. I think that coming back to your original question about the impact on organisations, perhaps a little bit of the background. I was while I was preparing for the webinar, and I kind of dived back in time when GDPR was published, and then we were all waiting until it would start to apply. And I remembered the discussions that a lot of organizations had how to prepare for the GDPR coming into force. At that time, it was already after the EU referendum. So the level of changes that organizations all over the UK and actually all over the EU has faced is actually quite big. And most recently, we have been all hit by the COVID-19 pandemic. So the level of disruption that we had and a lot of firms and a lot of organizations have faced is actually tremendous. And in this context, we now have 3 months to the end of the transition period, and I think it's great that we're sitting here together on the panel with representatives of the government and regulators, because it's super important for a lot of organizations to have clear and timely guidance, because that is what most of the organizations would like to have some clarity. And there have been events recently that have all put us waiting for updated guidance from regulators. I'm referring to the July judgment of the Court of Justice of the EU in insurance too. And I think that when it comes to members in different organizations, I think as in most sectors, the impact is very different on large international operators and smaller ones. So I think we all have to keep that in mind, that there would be large firms with international presence and there would be smaller firms. And we would like to provide the best support ever, the best support that there is available. And indeed, we are working on updated guidance for our members. We actually have already So the Law Society of England and Wales has already published some general guidance on the end of the transition period, where data protection is one of the points. There are 10 steps, and they refer to all sorts of business operations of law firms, such as employment, such as legal structure, etc. So I think I'm looking forward to the discussions, because in our work, in our guidance, we also rely on guidance from the regulators and available legislation.
Indeed, thank you, Anna. We've had a really good question that's come in on the YouTube feed from Andrew Brenton, which I'm going to come to in a second, because it's going into issues on Schrems. But just before we do, I just wanted to quickly come to Rhys and Charlie, just to say, is there anything you'd want to add there, just with regards to the impact of the UK withdrawal from the EU, and what's the impact on organisations that process personal data from the EEA? Charlie. Yeah, Charlie. Sorry, Rhys, if you're looking, I think we may have lost Charlie there. Rhys?
Yeah, I'm happy to. If Charlie's connections, I think, is broken. Just to sort of make some of those points again, and sort of you've been touched upon by both Annas on this as well, is that within this sort of wider context, with the impact that the UK, is seeking adequate decisions from the EU under, as you say, the GDPR regulation, law enforcement directive, this to allow the personal data to be able to continue flowing freely from the EU and the EEA to the UK after the end of this transition period, and to reinforce that this assessment is currently underway. The dialogue is continuing, and as again Anna B rightly points out, this is separate and distinct from the other discussions and negotiations on future relationship. And us as the UK government are positive that an adequate decision can be reached and underway by the end of the transition period itself. And also I would add, and try to go on to this, that the UK has legislated to transitionally allow for the continued free flow of personal data to the EU and the EEA states at the end of the transition period.
Thank you, Rhys. Charlie.
Hi, apologies about that. Yes, indeed, Rhys is completely right, and we are working incredibly closely with the Information Commissioner's Office, the ICO. We've issued guidance on gov.uk, and they are regularly issuing guidance on the ICO's own website. And we would encourage you to sign up to the ICO's newsletter, as that's where you'll get the guidance earliest. That's where they're releasing it first. We are cooperating, obviously, with the Commission in regards to our adequacy assessment. And as Rhys said, we've put appropriate safeguards in place, including forms of legislation, to ensure that we are able to share data as much as possible. But we would encourage firms to assess their own data flows, map them, talk to all of that, so that they're aware of what their current situation is, and if they do need to put in place any kind of alternative transfer mechanism, such as SDCs and BRCs that you've already talked about.
Thank you very much, Charlie. That's a very important point that you make in terms of checking those supply lines in terms of contractors. We ended up speaking a few years ago at a conference just a few weeks before GDPR came in, and we spoke to a compliance lawyer at one of the large law firms, and they were saying they'd had to review 3,000 contracts just as part of their GDPR compliance. And it's a similar exercise again, potentially, in terms of looking at a huge number of contracts to make sure that they are going to be sufficient to cope with the terms of the UK withdrawal. I suppose that brings me then just to the next quick question, which is, what do we advise our members, so solicitors up and down England and Wales at the moment, what do we advise solicitors, whether they're working in private practice, in-house, local authorities, elsewhere, what do we advise our members to be doing right now?
So as I mentioned previously, so the Law Society of England and Wales published the end of the transition period guidance, and that guidance is actually general. So it refers to all sorts of operations of law firms and aspects that law firms should check, but not only law firms. I mean, you have to give you an example. It's about employment laws, for example, and to see if you are based in the UK and if you are employing EA citizens, what conditions will that change? What do you need to look at? Likewise, if you have business operations in Europe and your employees move around, can you do that, and under which conditions? A large part of our work was actually about practice rights of solicitors, both in private practice and in-house. Of course, the in-house membership has additional sets of issues, and depending on the organizations they work for. But I think one of the pieces of advice already came from Charlie, and this is to review and understand your data flows. I think this is the first piece of advice that we gave, and to see what kind of data you process as well and how, and to understand how they move. And of course, if you do receive personal data from contacts or clients, then of course we encourage always our members to familiarize themselves with the guidance from the Information Commission's Office, the ICO. But likewise, there are several guidance notes that we also signpost our members to from the European Data Protection Board, because of course, if you process a lot of data from European citizens, the GDPR might apply to you anyway. So it's also whether you have which transfer mechanisms you rely to. So we advise to actually review them and check if they still apply. And of course, at this point, the advice concerning, for example, standard contractual clauses, which is quite a popular transfer mechanism, there's of course a rising uncertainty as to what kind of guidance will be issued by regulators after the Schrems II judgment, but also the SECs themselves are being updated, and we got the confirmation from the Justice Commissioner Didier Reinders recently that they should be ready by the end of the year. So actually, there's quite a lot of changes coming in the next 3 months. So one of the pieces of advice that we give as well is to keep checking for the updated guidance, because it might come, and I think that our colleagues on the panel would have hopefully some more insights on it. Thank you.
Okay, Anna B.
Thank you. I obviously fully support what Anna has just said, and just to explain further, I think we are all optimistic, and I think there are reasons to be optimistic about the prospects for adequacy findings for the UK. Obviously, it's not a given, and however, it is still a third state or a former member state with a legal framework for data processing, which is very, very close to the one we have in the rest of the UK. So the starting point is quite unique. It has not happened in the past for a country with almost identical legal framework to seek adequacy. So, on paper and just looking at these rules, it should be a very quick exercise. Obviously, in practice, it is much more complex because there might still be some differences between the rules on the books and the application in practice. I understand that this is possibly the case in some areas. Employment law was mentioned. And obviously the GDPR itself also allowed member states some flexibility in implementing and transposing some of its elements. So these areas where there is a margin for maneuver now obviously get scrutinized also with a different mindset, being adequacy possibly. However, there is also the issue of future UK legal framework. And so I believe that this is one of the biggest open questions, given the UK's stated objective of developing its own sovereign framework for data protection for the future, which hints at the potential or even maybe a guarantee of divergence for the future. So here, I believe for the Commission, it is also a certain challenge how to provide for an adequacy that is obviously intended to be valid for a longer period of time and to provide legal certainty for considerable periods in the future, how to cater for this possible divergence. So this is possibly on the table as well. And last but not least, indeed, certain issues related to what is called government access to data or agencies or public authorities' access to data. And I see that there are already some questions drawing parallels between this and the Schrems II judgment. Obviously, I would not go that far as to draw parallels between the US system as assessed by the Court of Justice in Schrems and what we have in the UK. But we all know that there is quite an extensive surveillance capability there, and also legal challenges pending both before the Strasbourg Court and the Court of Justice, notably in the Privacy International case, where, by the way, we will get the judgment already next week on Tuesday, so on the 6th of October. And all these elements, unfortunately, are also in play for future adequacy finding. And my final point is that time is also quickly running out, and we need to keep in mind that although adequacy is a prerogative of the European Commission, there is obviously a procedure in place for prior consultation with the committee, with the member states, but also with the European Data Protection Board. And for this consultation to be meaningful and for the board to be able to give an opinion, hopefully positive, I think time is really critically running out now. So my point would be that yes, let's hope for adequacy, but I would strongly suggest for businesses, for law firms, to try and be prepared. So to start looking indeed at possible alternatives that could be put in place, just in case there is no adequacy possibly yet at the time when the transition period ends. And this, I admit, must be a daunting exercise. As Anna mentioned, many of you have gone through the process of mapping your own data processing operations in preparation for the GDPR. And so at least you didn't have to worry about international transfers within the EU. Now, unfortunately, this additional exercise will have to be done, but I would strongly encourage that as part of this preparedness exercise for the end of the year.
Thank you very much for that, Anna. And we're getting some really good comments just with regards to the adequacy decision. One comment from YouTube user Info@Knowledgeance asks, does the UK go to the back of the line with regards to an adequacy ruling, or will they receive special preference? Another YouTube user, Declan Brady, has said the likely biggest threat to adequacy of SCCs is Downing Street's approach in the Internal Market Bill. That's the Internal Market Bill which passed the House of Commons last night and has now gone to the House of Lords. But Declan's point there is very much the trustworthiness around the admission there of potentially a specific and limited breach of international law by the UK. We've had another comment from Sarah Newman saying there have been some publicised statements from the government over the last few days which suggest the UK may change its data protection laws after Brexit. Would that affect an adequacy decision? And then Declan's also said, nobody with adequacy has since become inadequate, but the EU has expressed dismay over the messages being given. And a final comment just here from Declan, just saying, let's ask the nuclear question. What happens if by midnight, December the 31st, there's been no agreement, no adequacy? What should people be doing now to prepare for that potential eventuality? So that's all going down to the sort of issue of adequacy. So before, and we are going to come to a series of questions specifically on Schrems and the judgment there, but just on this issue of adequacy, I just wanted to put those comments into the mix for our panel to consider now, and then ask the question, what, in your view, are the potential hurdles preventing the EU from adopting an adequacy decision, and how could we hope that they might be resolved in the coming weeks? So, Charlie, I know you were waiting to come in. Are you able to come in on that?
On some of that, yes. So on the potential divergence of the UK and our data protection framework post the end of the transition period, obviously we will have left the European Union then, and we will be responsible for all of our own laws. We envisage these changing over time as the EU's will, as technology and business practices change. It's very important that we do keep up with whatever the latest developments there are. However, we are absolutely committed to keeping incredibly high data protection standards. And obviously, if we do achieve adequacy, which, as Anna said, we're in an incredibly unique position here. No country has ever approached this in such a strong position, because no country's ever left the European Union before and doesn't have such a robust domestic framework that is almost identical, as was said, to the European Union. So we're very positive. Adequacy, though, we do need to remember, does not mean identical to, it just means equivalent as, and we are committed to ensuring that that remains the case within the UK. For UK law and for UK data, as well as that coming from the EEA, we are in no means looking to reduce our standards at all. So hopefully that will give some level of confidence to the viewers at home. Looking though at Schrems, I know we're going to touch on this, but just to say that we do operate slightly differently to the US, and we still see the value, as the ruling said, in standard contractual clauses with appropriate safeguards. So we would very much encourage, as has already been discussed, any firm, whether that's the law firm itself or when you're advising your clients, to map your data flows and understand what may be needed in terms of alternative transfer mechanisms. We are positive that an adequacy decision can be made, but obviously we want to ensure that any risk is mitigated on behalf of the business community of the UK. We would very much encourage that you follow the guidance on our website and that of the Information Commissioner's Office, and do just ensure that you're doing all that you can to prepare.
Brilliant, thank you for that. So just continuing down the rabbit hole of adequacy, we've had another question, which is, to what extent does RIPA, Regulation of Investigatory Powers Act, potentially threaten adequacy? That's from Alex Matheson, who is a cyber lawyer. And we've also had another question just with regards to that from Andrew Brenton. While I'm no expert on the parallels between the US-UK surveillance process, well, I'm no expert on there are parallels between the US-UK surveillance processes which seem close enough that the same issues identified in Schrems will arise when it comes to the UK and adequacy. And indeed, another follow-up from there from Knowledgeance saying, totally agree. Regulation of Investigatory Powers Act, and Official Secrets Act will mean no adequacy outside of a trade agreement. So lots of thoughts there with regards to adequacy. Just wanted to see, Rhys, Anna, if you wanted to come in on that before we move on to the Schrems decision. Anna B.
Yes, sorry, just took me 3 seconds to unmute. Well, I think it is indeed fair to say that what the Court of Justice has done, both in the first and the second Schrems decision about the US transfer, so first invalidating the safe harbor decision and more recently the later privacy shield, they have certainly put the issue of government access to data right at the center of discussions about adequacy frameworks. So there is no way around these issues. And indeed, I believe that the scrutiny that will be expected from the European Commission in the context of adequacy assessment of these aspects, well, there will be a high expectation for this to be really done very thoroughly, especially since Schrems II. Now, the situation so far for the UK was different than potentially after the end of the transition period, because as you probably know, national security of member states of the EU is a matter for national competence and not for the EU to regulate or for the Court of Justice to review or to decide upon. By contrast, when it comes to national security of a third country and not a member state, this all of a sudden becomes a matter that falls potentially within the scope of the Charter of Fundamental Rights, of the treaties. And so there, the Court of Justice, as we have seen, does not hesitate to exercise jurisdiction and quite a forceful manner. So also the way EU lawyers and EU institutions look at, for example, the surveillance capabilities that exist within the UK will be different from the perspective that was taken before. And I do not exclude that these discussions will be complicated, will be difficult. But indeed, well, good news or bad news, that will depend on what the court will say next Tuesday. We will definitely have some indication from the Court of Justice, on how far this exemption from EU law can be claimed, whether in relation to a member state or a third country. So how far does the national security scope of regulation and action reserved for states go? And second, we may also expect the court to possibly say something about at least theoretical possibility for compliance for schemes such as bulk access to data under RIPA with the Charter of Fundamental Rights and with European law. So I think that these are going to be extremely important indications which may set the tone for some of these discussions further down the line in the context of adequacy, but also beyond.
Thank you, Anna. And indeed, we keep coming back to some of the issues that are raised in Schrems II there. And I think it's fair to say that in many instances it is all indivisible. It's all very much part of the same issue. So just so we can have the clarity, I suppose, for our audience out there who may or may not be familiar with the ins and outs of that, would anyone like to just give a quick run through of the main element of the judgment to Schrems II and the background there, and then we can start to bring in some of the impacts there with regards to that judgment on EU, UK and international data flows. I'm looking at Anna D, if you'd like. Briefly, if you'd like to give us a quick potted history of international data protection law for the last 5 years, go on.
Oh. Let's start. I mean, there were a lot of aspects of that. There's a long history for the Schrems II judgments, and there were a lot of aspects of it. Actually, there were quite a lot of questions asked in the judgment itself. But I think that the most important takeaways is that first of all, the EU-US Privacy Shield framework was invalidated, and I think for a lot of organizations that rely on it, this was quite an important outcome. And the second important outcome is that while the case actually concerned the validity of the standard contractual clauses as a transfer mechanism, that validity was maintained, but this is important, with a higher standard of due diligence, where now organizations have to assess the legislative framework of a country in which they import data. In most of the sources that I reviewed after the judgment and the comments, this also puts into question other transfer mechanisms as well, because if we are talking about the legislation of a country in which we import data, we obviously have to look at that, almost regardless of the transfer mechanisms. There were a lot of questions put afterwards. To what extent a contract between two parties can bind authorities in a third country? So there were quite a lot of questions that were raised, and I think of course. Yeah, I can see Anna. I actually wanted to ask Anna if she wants to come in on here, because of course the question of what to do next, what kind of guidance to rely, how to approach the judgment and how to comply with it, of course, became really important, especially that there is no grace period for the organizations that relied on Privacy Shield.
Indeed, and there were a large number of organisations reliant on that. Over the years, I've been pointing my clients when they're looking at the vexed question of international data transfers from the EU to the US to, the first port of call is to search the register and see the corporations that are on there. And most of the big US corporations are indeed on that register, and you can still go on there and search against it. But of course, its validity is now no longer valid is the problem. So coming back to Anna B on that.
I didn't mean to interrupt, or I rose my hand too fast, too quickly. I would like to stress once again that the Schrems judgment, of course, is important and impactful. But it was not about the UK. Let's keep that in mind. The court made quite a damning assessment there of the law that exists in relation to, let's say, mass surveillance or in particular mass surveillance programs in the United States. And while there might be claims that something similar might be happening also under RIPA, I think that there are also important differences. There is the fact that the European Convention for Human Rights has been applicable to the UK for years. There is the fact that I think judicial control in this area exists to a level which is absolutely not comparable with weak or non-existent oversight vis-a-vis EU citizens in the UK. So let's not go too far with the comparisons would be my first message. At the same time, Anna is absolutely right to say that there will be implications of the Schrems judgment to how we look at SCC standard contractual clauses more broadly. And there, yes, indeed, there has been a lot of noise and a lot of commentary going a little bit all over the place since the judgment came out, and I'm sure we will continue these discussions. But to me, and by the way, also for the rest of the European Data Protection Board, so for the national regulators, our reading of the judgment is that indeed SCCs could still be valid and used under some conditions, including for transfers to jurisdictions that are maybe problematic in terms of, again, government access to data in particular. So the sole fact that contractual provisions are not binding on the third country authorities is not an impediment to the use of the SCCs. And this is what the court says actually in the ruling quite clearly. Obviously, under the condition that the exporter supplements those clauses with additional guarantees. And these the question, what could these additional guarantees consist of, is obviously currently the million-dollar question in data protection law, and something that the data protection authorities in the EDPB have been working on for the past months and weeks. And we hope to be able to put out some guidance to companies about what those SCCs plus supplementary guarantees could look like together in the coming months, I should say. Possibly not by the end of this month, but hopefully soon thereafter. I cannot speak too much about the details of these discussions. I believe it's a bit too early. But basically, the idea is to look not only at additional contractual legal clauses, but also look at possible organizational measures or technical measures, such as, but not limited to, encryption. That would possibly not be, obviously, the silver bullet for all cases, but could provide supplementary guarantees in certain contexts. And so this guidance should be coming very soon. And I also should mention that the European Commission is indeed working on a new updated set of standard contractual clauses that is intended to take into account some of the conclusions of the court in Schrems II. Here again, we have no timeline. We have heard several times that this should be coming in the coming weeks. So let's hope that something will come out from the Commission side as well.
Thank you very much for that, Anna. And I think you've actually answered a couple of questions there that we've had in the chat. One of them was, is redress vis-a-vis government surveillance stronger in the UK? It's effectively non-existent in the US, and you've referred there to the UK's membership of the ECHR and our human rights record there, and the protections that are in there, which are of course very different from what's in the US. And indeed, right at the top of our discussion, one of the first questions we had once the chat was running was from Andrew Brenton, who asked, what about the uncertainty of SCCs caused by the Schrems II judgment? Would this not mean that SCCs are not adequate due to UK surveillance law? So indeed, I think you've taken us towards sort of an answer, a comment on both of those. Just to sort of refer to a few of the other comments that we're getting. Thank you for your comments on the YouTube chat. Please do keep them coming. Declan Brady has said, I think the UK rule of law is okay. The worry will be around oversight and whether what's permitted strays from EU expectations. There's also the question of protection for onward transfers, presumably then onward transfers to other countries. Andrew Brenton has then said, member states are subject to the CJEU. This is how the member state surveillance remains accountable. Once the UK leaves the jurisdiction, this will stop the accountability. Meanwhile, Andrew Cook has said, and the carve-outs in the Data Protection Act for immigration records and data subject access are already way out of line with what the EU regards as adequate under existing adequacy grants. And he's also followed that up with, if I was to want to find a client to do a Schrems III, it would be an EU citizen in the UK trying to get a subject access request on their refusal for settled status. So getting quite a few questions and comments, quite a few comments there with regards to the ins and outs of adequacy. So just looking to, we've talked there about Schrems, we've looked at the impact on data flows, we've talked a little bit about the state of play with regards to preparing guidance to organisations. So I just wanted to sort of go into that sort of point on guidance in a little bit more detail and just ask our panel, what really is the current state of play when it comes to preparing guidance for organisations? We've talked a little bit about sources of guidance and where our members should be looking as this information comes out, but I just wanted to sort of ask that question generally, just to say, is there anywhere else that our members should be looking, anywhere else they need to be mindful of when it comes to guidance around adequacy and Schrems II in the coming weeks and months? If the answer is no, we've already covered it, that's it, but I just wanted to give, in particular, Reece and Charlie the opportunity to come in there.
I think we've sort of covered most of it, and obviously So the .gov.uk website has a whole wealth of information, as does the Information Commissioner's Office. And we would also advise to just keep an eye on the Commission and other related websites as well. Yes, I think that's most of them.
Brilliant, thank you. Sorry, Anna, yes, Anna B.
Sorry, thank you. Yes, just to add once again, Anna, the other Anna has already been mentioning this. There is obviously the specific guidance that is being put out in the UK in particular now, and indeed by the ICO, by the government. There is also some guidance still put out by the European Commission with respect to the future of data flows, but it's less operational and more, let's say, based on principle. However, I would simply like to remind you that there is still a great deal of guidance on the various transfer tools available from the EDPB or even from the former Working Party 29. And for example, the guidelines on derogations might be also of interest to people in this context. These are typically those elements that, you know, as a company operating within the EU, you don't really look unless you plan to send data overseas. Now, voila, unfortunately, some data flows that were purely domestic within the intra-EU might become international data transfers. So these instruments will become relevant. But the good news is this guidance is already in place and has existed. So please do not hesitate to have a look at the EDPB website in particular. And obviously, some of that will have to be updated, and there will be new elements coming after Schrems 2. But not everything has changed as a result of Schrems 2. So a lot of these existing materials will already be helpful and relevant.
Brilliant, thank you, Annie. Anna, Reese, you wanted to come in. Sorry, Reese, I think you're muted.
First time this week.
It's the sound of the summer is someone turning around and saying, sorry, you're muted, but there we go. Sorry,
yeah, it's mine, isn't it? That's the picture of summer. Yeah, it was just to come in, just to sort of follow up on some of those things and to echo what Charlie had been saying. And particularly for those who have actually joined today, just kind of to signpost as well, if they aren't familiar with the ICO's website and some of the tools and the guides they have on there. I think it's particularly informative and useful. There are some interactive tools that, as Anna says, you know, for wider use of SCCs and being able to input in your information, your situation, your arrangements, and be able to get as clear a guidance on a sort of case-by-case basis as possible. So I would really encourage anyone who's looking for that little bit more clarity on any specific arrangements and so on to go onto the ICO website. There's also phone numbers, email addresses, the usual sort of icons to be able to contact as well, to be able to get into sort of some of the technical and nitty-gritties of their arrangements and how to move forward with sort of alternative transfer mechanisms.
Brilliant, thank you for that. So indeed, there are a lot. There's a rich amount of guidance and places to, unfortunately, a lot of places we need to make sure we're looking at to stay on top of all of that. Now, one area where this is going to change, of course, potentially in the fairly near future, is we've talked about standard contractual clauses. We've talked about the fact that these are fairly lengthy annexes that would need to make sure are present in any contract. And then the fact that we are potentially going to be seeing those revised standard contractual clauses in the fairly near future. And I mean, we knew that these were going to be changed before the Schrems 2 judgment came round, and indeed, to a certain extent, I think they've delayed revising them pending the outcome of that judgment. I just wanted to ask the panel if they had any views on specifically when we might expect to see those revised SCCs. And I suppose, not only when would we expect to see them, do we think we're going to see them this side of the end of the transition period, crucially? If anyone would like to volunteer on that one, I don't want to sort of pick someone out, But I can see Anna Drost smiling a lot at that. So I don't know if you want to volunteer on that.
I mean, the only piece of information that I have was the announcement in the European Parliament made by Commissioner Reinders, who announced the revision of the clauses by the end of the year. The expression "by the end of the year" to me personally means before the end of the transition period. But of course, the exercise of reviewing different contracts, as you mentioned at the very beginning, is actually a pretty laborious one for larger organizations. So, we just have to wait and see.
Yeah. And Anna B, yes.
Yes, if I may, just to confirm, I don't have a crystal ball or any more specific, more precise information from the Commission, but I can confirm that the intention is to have those new SCCs ready very, very soon. So let's hope that that this can indeed happen.
Indeed, don't worry. We'll settle for wild speculation in the absence of a crystal ball. But thank you. Indeed, it's a matter of we just hope that we get them before the end of the year, and I'd hope that that is indeed the case. So I just wanted to sort of add generally. I mean, we've sort of looked at what our members need to be doing. We've sort of looked at the main advice in terms of what our members should do. And I suppose another sort of a general review of that is currently to say that many organisations in the UK are processing personal data from the European Economic Area. So sort of briefly, what will change for them after the end of the transition period as it currently stands? What would they need to make sure they are doing in practical terms come January at the moment? If anyone wants to volunteer on that. Anna Drost, perhaps?
I think that beyond the guidance that we currently have, it's hard for me to actually say anything beyond, you know, doing the groundwork really, and to really to dedicate resources, first of all, to you know, it takes, I mean, of course, depending on the size of the organization, the resources will be bigger or smaller, but to make that an item on the agenda and to dedicate resources into checking the data flows and how you manage your data, how data is flowing. And also, I can only repeat that you know, to be aware of the existing guidance. Personally in my work, I also look at what's happening around Europe and also in the US as a response to the judgment, for example. So I know that there have been some guidance notes already published in some parts of Europe. There have been some announcements made. In the US, I think you know, preparing for an uncertain outcome is a little difficult because you know, you have to prepare for very different scenarios, and I think that is where the need for clarity and for certainty is very important. So I can only reiterate the messages that I've said earlier in this webinar.
Indeed. So I suppose just to sort of open that out, do you think we can sort of put together sort of three key issues that organisations should keep in mind ahead of the transition period in terms of what they need to be doing? Because, I mean, one of the comments we've had here on YouTube is we just desperately need a full certification scheme along with the adoption of ISO PIMS standards. But coming to the biggest question is, how do we tell if we are compliant? So what are those sort of three key issues that we think organisations should keep in mind ahead of the end of the transition period? Anna B.
Well, yes, I think we should. I would say message one, don't panic, and look at this as any other data protection compliance issue under the GDPR. So, as I said before, GDPR introduced the principle of accountability. So, unfortunately, the days when you would go with a notification to your regulator and ask, "Is that okay? Am I compliant? Please give me a clean bill of health." These days are over. Now it's accountability. So it's the controller who has to know what they are doing in terms of personal data processing, how it's done, and be able to demonstrate that compliance through documentation, through results of data protection impact assessment if necessary, and obviously all the other requirements which are in the legislation. So far, everybody should have gone through this process in order to ensure compliance. Now there is the additional complication of scrutinizing cross-border data flows, in this case with the EU, to identify them as possibly needing an alternative legal basis at the end of the transition period. So I think that Anna is completely right. This is the one thing to do. And then, as I said before, I think let's hope for the adequacy decision to be in place in time. But I would still advise people to try and be prepared, identify those data flows that absolutely have to continue for business continuity, for business criticality, and try and put in place alternative mechanisms for them to be available from the end of the transition period. Even only for the case if the adoption of the adequacy decision is delayed, which can always happen. We do not know how this process will go. We can discuss legal aspects, but I think we possibly need to keep in mind that the broader context of the ongoing negotiations and the future relation probably may play a role in this context as well. So I would suggest, map your data flows, assume that you may need a legal basis for them, even for a short transitional period after the transition period, and then try to put in place the mechanism which is the most relevant, the most appropriate for your case. And indeed, the GDPR provides for quite some catalogue of those in Article 46 in particular. But as I say, in some cases, it cannot be excluded that even 49, so derogations, might be perfectly okay in case of transfers which are not structural, not systematic, not large scale, etc., etc. So there is flexibility, but it's important to take some time and indeed assign some resources to that to be prepared.
Thank you for that, Anna. And I think it almost comes through to very much, like you said, don't panic, hope for the best, but plan for the worst to a certain extent. And I think a key thing here as well is that we keep talking about, making sure that, for example, you're carrying out a DPIA, that we're carrying out certain checks, that we're continuing to look for guidance where it's being published and going back and checking for new guidance along the way. I think a key element, though, is always to evidence all of these steps. And you were making the very important point there, approach this in the way you would any part of GDPR compliance. And of course, GDPR compliance always comes down to demonstrating compliance through things like everything from the minutes of a board where they've considered this to the minutes of a risk and compliance group or risk grouping or data protection officer responsibility within an organization to show that you are taking the positive steps to consider these issues, consider these risks and mitigate as far as possible given your resources, given the size of the organisation, given the resources that are available. I think it always comes down to what can you reasonably be expected to have done. So it's very much a matter of whatever you do, make sure it's evidence, make sure you can then provide that to the regulator, be it the fact that you can provide updated contracts, you can provide the minutes of meetings where this has been discussed, you can provide any other documentation that you may have put together. The more evidence you've got, the more you can say that we have complied with best practice as far as we possibly can. Rhys, you wanted to come in. You're on mute.
Again, brilliant. Just to briefly add to that, I think, and I've seen this sort of coming through some of the comments, that it depends on, again, some of the individual arrangements, circumstances for those businesses, for those firms in the UK. And for instance, you know, it may be the case that for UK business or firm who have actually no contacts or customers in Europe, you know, what are the arrangements for them they should be aware of, or guidance for businesses who send and receive data to and from Europe, those with a European presence, or any firms or establishments, and what they may have to do in those circumstances, as well as those who send it sort of outside of Europe. And I would again signpost that in each of those situations there'll be different steps that you should take, and you can identify online, again, like I said previously, through, for instance, the ICO sets out in those various different arrangements, what are some of the necessary and sensible steps that you should undertake to, as you say, map your data, understand where it's coming from, who it affects, what arrangements are in place, what documentation you have, and then they can provide as much sort of guidance and steer to the specifics of your arrangements as possibly can. So there are steps you can take, but it's useful to know where this almost the body of information is and the guidance is, so you can actually just sort of work through it and understand sensibly what's out there.
Brilliant. Thank you for that. So just moving on as well there, just wanted to sort of talk, we've talked briefly about sort of access to, we've talked briefly about the Law Enforcement Directive and access to databases as well. I just wanted to bring in one stat with regards to some of the systems that the UK currently has access to. So one, for example, is the Schengen Information Systems 2 database, active since 2013. Britain became a participant in 2015. Last year, the UK undertook 570 million searches of that database, making the UK the third biggest user. There's also the European Criminal Records Information Service, which enables the rapid sharing of criminal records, and the UK is a major user of that. There is also PRUM, which enables the exchange of DNA data, which is, of course, personal data. It allows someone to be identified. UK has been a participant since July 2019 up to June 2020. There were 12,000 initial hits relating to British investigations. So that sharing of data is clearly assisting law enforcement agencies at multiple levels, both in the UK and the EU, in terms of their ongoing investigations. And of course, when you think of the fact that many criminal enterprises are, of course, cross-border, when we think about everything from human trafficking to people trafficking, modern slavery gangs, all these sorts of things, very often they are multiple cross-border, exploiting the most vulnerable people out there. And clearly these tools are incredibly important when it comes to the sharing of that data and being able to bring people to justice. So I just wanted to briefly look at the fact that currently, obviously, we're relying on these networks, and that is also something that could potentially be lost come January. So I just wanted to sort of bring that up and put that into the mix in terms of, do we think that we are going to be able to continue to get access to those, or is it going to be a matter of alternatives being found? I don't know if anyone's able to come in on that at all. Anna, Anna B.
It's me again. Thank you. So, no, thank you, Peter. I mean, you are raising obviously a very, very important point. I guess this is maybe not of direct concern to some of our listeners, viewers today. But I can say that the issue of adequacy under the Law Enforcement Directive and by extension the issue of access and data sharing with the UK in the context of police and judicial cooperation, border management and access to the large-scale systems like the ones you mentioned, but also data exchanges with the agencies such as Europol, are absolutely on top of the agenda and top of the mind of the European Commission and of the EU institutions. It's interesting actually to see that the Council, when giving its negotiating directives for the future partnership, for the future relationship between the EU and the UK, made this one of the main priorities. So at the same time, here again, I think we will probably have to wait and see what can be done in terms of adequacy decision under the Law Enforcement Directive. I'm afraid I don't have any more indication about this, the status of this project, any more than I would have about the one under the GDPR. Only that there was a firm commitment from the Commission at some point to deliver both before the end of the transition period. So that's one element. I believe that some of the other specific data flows and frameworks for data exchanges will possibly have to be sorted out in specific separate negotiations. So even the two adequacy decisions will possibly not solve everything. And I know that discussions and some steps to be able to ensure data flows in this context have been already undertaken. So yes, this is absolutely a very crucial point where I believe the interest is very much mutual. So both from the side of the UK, but also on the side of the EU, to make sure that the cooperation and the security field can continue.
Brilliant, thank you for that. Just before I go on to now a few of the questions that have come in from the audience, just wanted to check if any of the other panelists wanted to come back on that point. No, okay. So I just wanted to go, I had one very good question from Sarah Newman on YouTube saying, where should UK businesses go to find a representative in the EU, and what duties does that representative have to take on? So I suppose this is where you're looking at a UK business thinking, okay, now we're going to find ourselves outside the EU, come the end of that transition period. Do they need to find that representative in the EU, and what duties does that representative have to take on? Anyone wants to come in on that generally? I think one of the key issues is, of course, where you're going to be looking for a EU. Of course, the ICO is no longer a regulator in terms of GDPR at that point. So, for example, if you've got a UK business with European offices, and it may be the point that if you've got a office where any key decision making is being taken, then that office can, the country where that would be, for example, the regulator that you would end up using in that instance. So, for example, if you've then got an office in the Netherlands, then it would be the Dutch data protection regulator you might end up working with. Please do keep on your questions and comments on YouTube just coming in. We've got another about 10 minutes or so just to be able to address any specific questions that you might have. I just wanted to...
Peter, excuse me.
Sorry, Anna, yes, Anna B.
Can I just quickly come back to the point about representative? Because I think here there may be... I mean, it's difficult to give specific legal advice in this format, but I think it may be different things. There may be indeed a question of where will my main establishment be in the context of the GDPR after the end of the transition period. There may also be a question of the representative under Article 27 GDPR. But I would just say that especially the latter only would apply if we all agree that there is, that the UK is a third country with no adequacy, and then in the specific circumstances where GDPR would still apply to this business by virtue of its Article 3.2. So we also should not generalize. It's not a general requirement for everybody to appoint a representative in the EU. Only under in specific circumstances, which of course might be the case here, but voila, let's not mix up all those different situations. I know it may be daunting and complicated, especially if voila, from an intra-EU flow you switch into dealing with international transfers, but voila, let's not put the hurdle too high, I would say, in terms of compliance.
Okay, thank you very much indeed for that, Anna. I think as we now sort of move towards wrapping up, I just wanted to ask the panel generally. I asked the question earlier on with regards to sort of what what are the top three issues that organisations should keep in mind at the end of the transition. I suppose what are the main takeaways? What are the main bits of advice that we would taking away from what has been a long discussion here? What are the main takeaways that we would give to our members, to solicitors who are advising their clients across England and Wales? What are the main takeaways that we would want them to have? What are the main pieces of advice we want to make sure that they have leaving this discussion that they can take away when they're then looking to help their clients over the coming weeks and months?
Well, if I may, I think, yeah, I'll just reiterate some of the points I made earlier. But of course, first of all, keep an eye out on our guidance from the Law Society of England and Wales, because of course we have published several pieces of advice already. But as we go, and as the guidance from different regulators will be released or updated, we will work, of course, on updating ours and actually reflecting that in our advice. I mean, as I say, of course, we signpost to quite a lot of existing resources, and there was a question about the EU representative. I believe that there is a guidance from the European Data Protection Board on that point as well. And guidance on a point, on choosing lead supervisory authority, etc. So there's actually quite a lot of guidance at EU level that can be applied already, or that can be used to a large extent. So that's one of the advice. And yeah, I totally agree with Anna's earlier recommendation of not dedicating some resources to do some groundwork into reviewing existing data flows, existing transfer mechanisms, and understanding how data moves and what kind of impact a given firm or an organization is dealing with. So those would be my takeaways for the moment.
Brilliant, thank you. Would anyone like to add to those? Anna.
Yes, absolutely. Just to agree with Anna again, a lot of guidance is already there. So I would say, let's hope for the best. That is, for adequacy decision to be in place by the end of the year, but be prepared to use alternative legal basis for the transfers. And don't hesitate to start in the first place from the guidance which is already available from the EDPB in particular on derogations notably, but there will be more guidance coming up on the use of SCCs and on the use of supplementary guidance. And let's not forget, as we said before, the Commission has promised also new sets of standard contractual clauses, which to my understanding should also, to answer one of the questions, should cover not only transfers from controllers to processors, but also processor to processor and even processor back to EU controllers. So if this really comes through, it will surely be a very valuable resource for you as well. So a lot of guidance is already there. Don't hesitate to use this.
Thank you, Anna. Charlie.
Just to really reiterate everything that's been said before by both of the Annas, we are very much hopeful for an adequacy agreement, but we can't guarantee it at this point. So do take the steps in place. And there are a number of places here, the Law Society, ICO and gov.uk. So if you need help, there are people here to help you. The ICO, as Rhys said, has got a brilliant interactive toolbox. They've got people on hand to talk to you. So do give them a call if you've got any problems, and we are here to support you as much as possible. We want to make sure that risks are mitigated and that alternative transfer mechanisms, where necessary and appropriate, are in place.
Thanks, Charlie. And just to confirm, because I know it was one of the questions that we had in the YouTube chat, we had one question on whether there was sort of a queue in terms of adequacy decisions and whether the UK might currently be at the back of it. But I think from what you've just said, that the answer to that is that very much the discussions are ongoing and that we are hopeful for that adequacy decision before the end of the year.
Very much so. We are in live discussions at the moment, and we are very hopeful that it will happen before the end of the transition period.
Brilliant, thank you. Question from Sarah Hook on YouTube, asking, in terms of standard contractual clauses and the privacy shield, how do we deal with a situation where a data controller sells their company to a US entity, but there is a services retention period, and the company selling becomes a processor of the US entity? So I mean, obviously we can't go into specific legal advice here, but just a sort of general, if anyone's just able to give some sort of general views with regards to that scenario.
I saw the question and I was thinking it's very interesting, but unfortunately I have no thoughts maybe yet, because this is the level of technicality. I would have to think a bit more about it.
Yeah. Yeah. Okay. Good. Just going on there, we've continued to have some really good comments on the from the YouTube chat there. Just for example, saying that clients just want to know what they need to do and how. So it is quite excruciating for them and expensive, and indeed that is indeed the situation that we find ourselves in. And indeed some of these questions are very, very technical that we simply cannot resolve, given the we don't know exactly what the situation will be as of the 31st of December. But at the moment, as I said earlier, it's very much a case of hope for the best but plan for the worst. And I can say that in my own experience, I'm currently advising my clients where they are in any doubt and wanting to make sure they're doing anything about it, to say, right, in that case, presume that we won't have an adequacy decision. What would you do in that scenario? And plan around that. And if that means relying on the standard contractual clauses that we currently have, that's what we have to do, and then update them as and when that happens. So it is at least possible to hopefully be able to take remedial steps to a certain point, and certainly be able to plan for the worst and have a plan in place is always the key thing. That's coming up towards the end of our discussion. I just wanted to ask our panel if they have any final words that they would just like to say to our audience before we finish off. So just a sort of last few words from each panelist. Anna B, would you like to start us off, and then we'll work our way around?
I just would like to say that the regulators, believe it or not, the data protection regulators, the DPAs, are very much aware of the predicament in which many businesses are finding themselves now, or expect possibly to be in the coming months. So we do work very, very hard together to be able to provide guidance, templates, advice. But this unfortunately requires time, at least if we want this guidance to be sound and agreed in a harmonized manner at European level. I think there is a value in having these positions agreed, but agreeing them across all the member states plus the 3 EEA members of the EDPB unfortunately takes more time. So I understand that many people are impatient, but please be assured that the regulators do realize the difficulty of the situation and are really working as hard as they can to deliver this clarity and this guidance as soon as they possibly can. And I'm sure the same considerations apply to the European Commission, who also work on several fronts, not only to prepare the adequacy assessment and to be able to deliver that, but also to prepare the new SCCs, which, as I mentioned earlier, I understand are intended to cover various configurations. So also from processor to controller, as was mentioned in several questions. And thank you very much for having me on this very interesting panel.
Thank you, Anna, and thank you in particular for your insights and sharing such a lot of information with us today. Rhys.
Yeah, thanks, Peter. I'd sort of reiterate the point that it's in everyone's interest that the free flow of personal data between the EU member states and the UK continues for the commercial, general law enforcement, everything we've sort of touched upon for this webinar. I highlight in the political declaration between the UK and the EU, they've both stated that reaching an agreement on adequacy is paramount and is critically important for both sides, and that's why, as Charlie's been detailing, that process is live and underway at the moment. I continue to add that the guidance and the support that is online, government.uk, the ICO website, the ETPB, and there'll be further oncoming guidance in those related areas shortly. And where where possible, UK government has sought to be pragmatic where it can be. So, for instance, legislating to transitionally allow free flow of data to the EU and EEA states at the end of the transition period. So continue to watch this space, and thank you again for arranging this panel, for Law Society for arranging this, for Peter for moderating, and for everybody. Hopefully it was useful for all of you who've joined today.
Thanks, Rhys. Charlie.
To thank all of you for tuning in. It's really gratifying to see such high numbers of you interested. All I can really say is reiterate what's been said, and please do map your data flows and just really take stock of what's going on and what you may need. We are incredibly hopeful that we will have an adequacy decision secured, but as you know, a multitude of factors play into that, and we just can't predict what's going to happen. So please do mitigate against the worst, as Peter said. Hope for the best, but prepare for the worst. And thank you to the Law Society and Peter and the other panelists. This has been really fascinating. Thank you all.
Thank you, Charlie. And finally, Anna in Brussels.
Hi.
Yes, we can hear you.
Oh yeah. Sorry, no, it took a while to unmute. Sorry. I can only repeat the advice, by my fellow panelists. I think it's been a great discussion, and I'm really happy to have been on this panel and to be sharing exchanges with you. But also, I've been peeking at the comments as well, and the exchanges are also extremely interesting. And I think that we'll be working hard on providing the best support possible. We ourselves are awaiting as well on further guidance coming up. So watch this space, and I hope that I hope that we'll be able to provide the best support and advice possible in the near future. Thank you.
Thank you, Anna. And I think as well, just to give you a quick plug, there is obviously the existing guidance on the Law Society website, and also things that the Law Society is working on that will be coming out in the coming days as well. Are there any particular pages that we need to flag up to our members to take a look at on the Law Society site, or in terms of where all that information?
Yes, I'm happy to share that with the participants and share the link and send a separate message. If that would be good, because I don't remember the. But if you go to the website of the Law Society of England and Wales, lawsociety.org.uk, I think that the preparation for the end of the transition period features on the main page, so it will take you directly there.
Excellent. And as you say, we'll circulate to all the registrants an email with a few links on afterwards as well. And as far as I know, the recording of this webinar, I know a few people missed the very start of it or have joined us during the course of the stream. The entire recording will be available for access and download afterwards. So please do feel free to take a look at that. But can I thank all of our panelists for giving up their time and sharing their insights with us today. It's been incredibly valuable, and we're very grateful to you all for doing that. Can I thank the staff at the Law Society Anna and her colleagues who've organised this at the Law Society's Brussels office, and also our technical staff who've been working in the background on the live stream, putting together all the arrangements for the event today and making sure that hopefully a nice recording of both the audio and video element of this discussion is available online. So thank you all very much indeed for joining us in the UK, across Europe and around the world. And we look forward to seeing you again soon on other Law Society events and webinars. Thank you all very much indeed. Goodbye.